in, but we're going to kick things off. Hello, everybody. I'm pleased to welcome you to this important webinar on the law of war. My name is Colin Diamond. I'm a partner at Whiting Case, and together with Uri Hertzberg at Debevoise and Alex Kaufman at Paul Hastings, we organized this webinar on behalf of the Jewish Lawyers Network. JLN grew out of the thousands of lawyers who initially signed a statement condemning Hamas's attack on October 7th. I'm very pleased that we have such illustrious participants in today's webinar. Natasha Hausdorff is going to moderate our panel today. Natasha is a barrister and is herself an expert commentator on international law, including the law of armed conflict, foreign affairs, and national security policy. She holds law degrees from Oxford and Tel Aviv universities and was a fellow in the National Security Law Program at Columbia Law School in New York. Without any further ado, Natasha, thank you for leading our discussion today, and over to you.
Well, thank you very much indeed, Colin. It's very good to be with you and to welcome you, ladies and gentlemen, to this extremely topical webinar on the law of war. In the month since the start of this war and the atrocities committed by Palestinian terrorist organizations on the 7th of October, we have seen continuous coverage of developments and supposed analysis of international law on broadcast media and social media, coverage which has consistently misrepresented what the law says and how Israel is acting on the ground, and whether its actions are in compliance with international humanitarian law. Now, it's plain that we have been witnessing an effects-based analysis rather than a conduct-based analysis as mandated under international law. And these errors have been repeated by representatives of NGOs, international organizations, and some international lawyers. So for a better understanding of the law of armed conflict, how it applies in Gaza, and what it means for the proper assessment of the legality of the conduct of Hamas and the actions of the IDF, I'm pleased to be joined by two distinguished experts in the laws of war. Professor Geoffrey served in the US Army for 21 years, holding a variety of senior legal roles, including as the Army Senior Law of War Expert in Panama, as Chief of International Law for US Army Europe, as Professor of International and National Security Law at the US Army JAG School, and as Chief Prosecutor for the 101st Airborne Division. He's currently the George R. Killam Jr. Chair of Criminal Law at Texas Tech Law School. Arthur Traldi is a senior fellow with the Technology Law and Security Program at the American University in Washington College of Law. From 2010 to 2017, he served as a prosecutor at the International Criminal Tribunal for the former Yugoslavia, litigating cases involving genocide, crimes against humanity, and violations of the law of armed conflict. Arthur has also served on teams making submissions to the International Criminal Court, the United States Supreme Court, and the European Court of Human Rights. He's previously served in chambers at the International Criminal Tribunal for Rwanda also. Now, there are many questions that we've had in advance, which I shall be posing to our panel, but please also add your questions to the Q&A facility in Zoom, and I'll seek to put them also to our panelists. Now, Israel withdrew entirely from the Gaza Strip in 2005 in a unilateral move that sought to further facilitate Palestinian self-governance. After the first and only elections in 2006, Hamas staged a violent coup in 2007 and has ruled the Strip absolutely since then, turning it into a base for terror over the last 16 years. Gaza sits between Israel to the northeast, to the north, and of course Egypt to the south, and the Mediterranean Sea to the west. It's approximately 25 miles long and between 4 and 8 miles wide. It's home to over 2 million people. Many of the communities who were uprooted from Gaza in Israel's withdrawal in 2005 settled in communities in the south of Israel bordering the Gaza Strip, communities which in part lie within a few miles of the Gaza border and which were subject to the terror attack and atrocities last month. Following the October 7th attacks, Israel's war against Hamas has proceeded with a stated objective of destroying Hamas and its military capability. Arthur, in that context, may I begin with you and your analysis of this constant refrain, these allegations we hear of breaches of international law? Could you begin with an introduction of what international law applies, where it has come from, and who applies, and forgive me, who it applies to?
Sure, and thanks for having me, Natasha, and thanks to JLN for organizing this event. First, I think it's important to say, and this is not a legal position, that human deaths are tragic and wars are terrible, and the consequences of lawfully waged warfare don't stop being tragic just because they're lawful. But knowing what is and isn't lawful is still really important, in part because there are times that both the law and our common sense tell us that states have to fight and we want them to fight fair. So with that said, international law on war or anything else primarily comes from two places: treaties, which states sign up to, which bind the states that sign up to them, and what's called customary international law, rules accepted by all or almost all states as rules that haven't been written down. And in this context, more than anywhere else, the rules will come from the 4 Geneva Conventions that all states agreed to in the aftermath of World War II. There are a couple of related but distinct types of international law that have grown out of them that are relevant to our discussion today. International humanitarian law, or the law of armed conflict, which sets out what's expected of states that are involved in a conflict or warring parties involved in a conflict. And international criminal law, which sets out when individuals may have criminal responsibility for violations they themselves may have committed during wartime. Now, under IHL, we may think about whether a violation gives rise to state responsibility, but states don't commit crimes in exactly the same way. When we say crimes, we're talking about individuals. That law applies to the US Army, the British Army, the IDF, Hamas. Nobody is above international law and nobody is below it, meaning the same rules apply to all sides, and that we figure out what rules apply to a given side in the same way, whether they've signed up to a treaty, whether it applies in a particular territory. We're going to discuss a lot of the details, but maybe to frame the IHL conversation, it's worth noting here the key principle the law sets out. There are a few, but the one biggest one, which is that all parties must distinguish at all times between civilians and combatants and target only combatants for violence. There are some additional details in lay terms trying to limit the accidental consequences for people who aren't participating in hostilities and not doing super cruel stuff, even to people who are participating in hostilities. But the obligation to distinguish is the biggest principle that's going to underlie our discussion, so I think it's worth getting it right out there to start. And to be clear, as Natasha foreshadowed, these legal questions are going to be evaluated based on a party's intentions and their conduct, not based on outcomes. That is, if you would picture a party firing a shot, the question is what they shot at, and perhaps whether they took sufficient precautions, not what they wind up hitting. We don't try to reverse engineer a conclusion from that. All right, that's enough from me for an introductory remark, I think.
In that case, can I pick up specifically on the 7th of October massacre and ask what you see as the key international law issues arising from that attack specifically?
We could easily spend an hour on this, but I'm going to try to only spend a few minutes. The publicly available evidence that I've seen, and I haven't investigated it myself, but the publicly available evidence I've seen suggests prosecutors looking into the attack should be carefully investigating the likelihood that international crimes were committed. Those come up in a few main categories: crimes against humanity, war crimes, terrorism, genocide. And I say categories because crimes against humanity and war crimes are like felonies and misdemeanors. They're categories of crimes, not individual crimes themselves. And I should say, by international court standards, the publicly reported allegations here are very serious. For instance, while prosecutors are not always in an international court able to prove exactly how many people were killed in a particular massacre, it appears that if reports of fatalities at the massacre at the Supernova Sukkot gathering, the trans festival in Re'im, that incident would be as deadly or deadlier than any single massacre that has been part of a case the International Criminal Court has done in its 20-year history. While it doesn't match Srebrenica in body count, October 7th would have been one of the deadliest days ever part of an ICTY case too. And if you compare it to, for instance, the Special Tribunal for Lebanon that was dealing with a very important bombing, but one where 22 people were killed. You see the gravity of these crimes, to use the international law term. Getting back to the categories, just so we understand them, a crime against humanity will be one of a few offenses committed as part of a widespread or systematic attack directed against a civilian population. Among the crimes against humanity recognized in international law that prosecutors might look into related to October 7th are murder, what's called extermination, which is murder at a massive scale, unlawful deprivation of liberty, rape and other forms of sexual violence, and what's called persecution, targeting people for violations of their rights because of their membership in a particular type of group, like race, religion, ethnicity, or nationality. And we've seen what appears to be public evidence indicating that all of these crimes might have been present. And war crimes, then, are crimes committed with a connection to a war. One of the many uniquely challenging things about this conflict is there's not a universal consensus on whether it's non-international or international and what the right type of classification is. But either way, while that affects what the rules are somewhat, there are a few allegations a prosecutor would definitely want to look into: unlawful killing, hostage taking, directing attacks against civilians, sexual violence, and torture and cruel treatment, perhaps primarily. The third category I mentioned is terrorism. And if you look at, for instance, the Ayash judgment from the Special Tribunal for Lebanon, they describe that under international law as a crime or the threat of a crime committed with the specific intent to spread fear among a population or coerce a government. And you see indications, certainly in the way crimes were carried out, that spreading fear was part of the goal here. And then the fourth and most challenging to prove is genocide, which can be one of several violations, particularly, though not exclusively, murder or rape, committed with the intent to destroy a national, ethnic, racial, or religious group in whole or in substantial part. So you'd imagine, with those kind of categories of potential crimes in mind, good prosecutors would be focusing on a few things: collecting, analyzing, and preserving evidence of the physical crimes, who was murdered or raped, figuring out, as we've seen some publicly released, what's on dash cam videos from cars that were nearby, what will enable us to identify victims, whether that shows potential perpetrators on the videos. And there's been some reports that the urgency of identifying murder victims has delayed the collection of some other types of physical evidence, some of which may be lost. And it's important that urgent action be taken to collect as comprehensively as possible. But that's the first: collecting, analyzing, and preserving evidence. Second, what are the most straightforward ways to link these crimes to organizational leadership? That is, to identify the people most responsible, the architects of the crime, assuming the crimes themselves are able to be proven. Do they match, for instance, statements by organizational leaders or calls for crime? For instance, if a spokesperson were to make threats to harm people that a group was detaining in retaliation for particular actions or in order to deter an enemy force from taking particular actions, that would closely parallel the legal elements of the war crime of hostage taking and would help with linking, both showing the group had control over those detained people and showing their intent to commit that particular crime. And third, what can be proved about the more general elements, whether the perpetrators were seeking to destroy a national group in whole or in substantial part, whether they intended to spread fear among a population, whether their attack on civilians was systematic, and for international criminal court purposes, whether it was part of an organizational policy. And on all those, but particularly the genocidal intent question, again, we're thinking about the intentions of the criminal operation. And so not just what perpetrators did, but what they'd intended to do and set out to do. So for instance, if more people would have been killed had the attack not been eventually pushed back, it's the part of the group that was targeted for destruction that's relevant for the inquiry about whether the attackers intended to destroy a substantial part of the group. Those are the international law issues, but of course there are also potential crimes to be investigated under Israeli law, under American law, under the War Crimes Act, and under other places, and under some European countries' laws as well. And so if those issues are focused on appropriately, you might expect cases would wind up in a couple of different jurisdictions, a lot like we've seen with cases involving ISIS perpetrators and other perpetrators of alleged crimes in Iraq and Syria.
And of course, what we've heard from the Hamas leadership and also from those that have been taken into custody in Israel as to their intentions is critical to supplement the analysis that you've given. Arthur, thank you. Geoff, having dealt to an extent with the 7th of October massacre, can I ask you about Hamas crimes after the 7th of October? Could you outline the key international law issues related to Hamas actions in that subsequent period?
Well, let's start with a basic principle that Arthur mentioned, and that's equality of application. It's a foundation for international humanitarian law, aka the law of war's regulation of hostilities and the protection of victims of war, which are the two principal sources of obligation under the law. The Geneva Conventions codify rules related to protecting victims of war. Rules related to the conduct of hostilities, interestingly, are not in the Geneva Conventions. They don't address how you fight. Those rules grew through customary practice and were ultimately codified primarily in a treaty in 1977 called the Additional Protocol 1 to the 4 Geneva Conventions. Israel and the United States are not party to that treaty, but those provisions are largely, in large measure, considered customary international law. So they're applicable to both the IDF and to any organized armed group engaged in hostilities with the IDF. Now, this is an important point. You don't have to be a state to be bound by international humanitarian law. I mean, Arthur worked in tribunals that dealt with war crimes committed in the context of what international lawyers call conflicts not of an international character. That's code word for an armed conflict normally between a state and a non-state organized armed group. If you're an organized armed group and you participate in hostilities, you're bound to the same basic principles of law as the armed forces of the state you're fighting. That means Hamas is obligated to follow the rules of war no differently than the IDF is. And one of the misleading aspects of the public narrative on this situation is the acknowledgement that Hamas committed war crimes on October 7th, which is basically impossible not to acknowledge because we have video evidence of it. But the failure to acknowledge that Hamas is continuing to commit war crimes ever since then. The rules related to attacks, the conduct of hostilities, focus on the decision to launch the attack, not on the outcome of the attack. And that's why at the beginning, Natasha, you mentioned the problem of effects-based condemnation, which you've heard me talk about, and I'm sure you've read stuff that I've written about it, the distorting effect of looking at the effects of an attack and drawing assumptions about whether or not that attack was lawful. That has two principal problems. Number one, it is not uncommon that a commander can make a good faith and reasonable judgment to launch an attack, and the facts might not be as he was able to determine, and the outcome might not be as he intended it to be. So there might be an effect that looks like it was improper, resulting from a completely legitimate attack decision. And if we condemn the commander for doing that, we're holding the commander to a strict liability standard that nobody engaged in war could ever live up to. The more fundamental problem with it is it gives a pass to parties who launch attacks trying to kill civilians and fail to achieve that result. If you are directing your attack at the civilian population, or you are using indiscriminate weapons or attacks against an enemy area, those are both war crimes. They both violate international humanitarian law. It doesn't matter whether you achieve your malicious result. So every one of those 10,000 rockets that has been launched against Israel, not against IDF bases, not against Israeli targets, Israel, has been a war crime. Every time a trigger has been pulled, an order has been issued to launch the attack, it's been a war crime. Fortunately, Israel has been able to prevent the illegal objective from being achieved through defensive measures, but it doesn't mean that those are not war crimes. So there's one category of war crime. Another category of war crime is hostage taking. Hostage taking is an ongoing war crime. Every day those hostages are in deprivation of liberty, there's an ongoing war crime. And it's almost perverse when the two hostages were released, that it was reported as a humanitarian gesture. You cannot engage in a humanitarian gesture in response to your inhumane act. It's perverse. The hostages need to be released, and if they're not released, it's a continuing war crime. And as Arthur says, everybody in the chain of command that's involved in that is now complicit in it, because they all know about it and they're condoning it and encouraging it. Human shielding. If you use civilians to shield military targets, that is another war crime, another clear violation of the law. Now, it doesn't release Israel of its obligation to do everything that's feasible to mitigate the risk to civilians when they're conducting an attack. But it obviously makes that risk mitigation effort incredibly difficult and leads to situations where there's no option other than to launch an attack with full knowledge that it's going to result in incidental death or injury to civilians. And I have to say, I think at one point there was reference to accidental injury to civilians. These are not accidental injuries. These are calculated injuries. That's what commanders have to do. That is the burden of battle command. You have a target. It's a legitimate target. It has value. The enemy has put it in a location where it's impossible to attack it without causing civilian casualties. And an individual, a commander, has to make that judgment that the value of that target outweighs the consequence to the civilians of launching that attack. But the use of the human shields is itself a war crime. And in fact, and Natasha knows this from an event earlier today, in my view, even the phrase human shielding doesn't fully capture the gravity or the depravity of Hamas tactics. The notion of human shielding is that I'm using a civilian to prevent you from launching an attack. In my view, Hamas routinely wants the IDF to launch the attack because they need those civilian casualties to advance their information campaign. And one thing people need to know about groups like Hamas and ISIS and Al-Qaeda, for them, information does not support their combat agenda. Combat supports their information agenda. And when every casualty in a conflict is characterized as a civilian casualty, and it is interesting, isn't it, that when we hear the casualty numbers, apparently there are no Hamas fighters who have been killed in battle because everybody being reported is apparently a civilian. We know the effect that has on the public conscience. So I refer to this as indirect civilian targeting. You're using the enemy's military assets to murder your own civilians because you want them to get killed. That's not human shielding. That's even more aggravated. That's murder. And that's a war crime. And the fact that Hamas is deliberately embedding its vital military assets in hospitals, we have evidence of this now, clear video evidence. Again, it's abusing the most highly protected object in the battle space, which is a medical care facility. That dilutes the protection of medical care. Using ambulances to transport belligerent operatives and equipment and ammunition dilutes the meaning and significance of the emblem of protection. These are all some of the most severe war crimes recognized throughout history, and this is pervasive conduct on the part of Hamas.
Jeff, it's appropriate that we also move on to discussing Israel's response to the 7th of October, and you have done so with respect to Israel's obligations under international law. Could I zoom out for a moment and ask you to set out the scope of Israel's right to self-defense? It is an inherent right, of course, recognized by Article 51 of the UN Charter, but could you set out any limits on Israel's right to self-defense in international law?
Certainly. I know that the audience, everybody has familiarity with the notion of self-defense in the civil context and for individuals. The best way to understand this is to just view the state as an individual in a community. Just like an individual, when the state is the victim of an unlawful, imminent, or actual armed attack, the state has authority to act in self-help and do whatever is necessary to restore the security. Now, the difference is if you're the victim of an armed attack on the street, you can act in necessity to protect yourself, but ideally some external agent like law enforcement will come and take over the problem. That doesn't happen in the international community. It should, it's supposed to, and that's why in Article 51 of the Charter of the United Nations, when a state acts in self-defense, it's obligated to notify the Security Council. The theory was the Security Council would then intervene to restore the state's security. When that doesn't happen, then it all comes down to the principle of necessity, which is the very foundation of self-defense in any context. The state is permitted to take those measures that are necessary to restore its national and human security. And what October 7th demonstrated was that Israel's assumptions that its security could be protected sufficiently by using less aggressive means, for example, Iron Dome and border security measures, was thrown in the trash bin. In 2014, Israel responded in self-defense to similar attacks by Hamas, but far less grave. And Israel responded in a much more limited manner. They entered Gaza because of the tunnels. My view was they could have taken more robust measures, but they made a calculated decision that this was all that was necessary to achieve their self-defense. On their northern border, they are acting in self-defense against periodic attacks by Hezbollah rockets. They're choosing to have a very limited response. But what we see in Gaza is an acknowledgement and a recognition that the principle of necessity at the core of national self-defense demands that Hamas's military capability be totally destroyed. That is a military operational task, destroy. That means that you take action against an enemy to prevent the enemy from being operationally effective, from being combat effective without substantial reconstitution. That's how you translate the strategic objective of self-defense, which is to ensure Israel is safe, to the military operational objectives that are being implemented on the ground. It's not tit for tat. There's no rule that says if 1,000 Israelis get killed, you're allowed to kill 1,000 on the other side. That's not how self-defense works. Self-defense allows the state to do what's reasonably necessary to eliminate an ongoing threat, and that's what we see happening on the ground in Gaza.
A significant driving force, of course, behind the development of the modern law of armed conflict and international humanitarian law focuses on the protection of civilians. What obligations does Israel have to mitigate risk to civilians? And could I ask you to comment in that vein also on the distinction between humanitarian pauses and ceasefires?
Sure. So let's start with the first question. I want everybody in the audience to imagine the challenge of commanders in the field in Gaza right now. They're having to balance two fundamental obligations. The first obligation is the obligation derived from military necessity. Do all that is necessary to bring about the prompt submission of your enemy in the most efficient manner possible. That's what military necessity means. In military terms, military commanders would tell you, my mission is to use combined arms, fire and maneuver to close with and destroy my enemy. That's what commanders are taught. That's the violence of conflict. But they have to balance that aggression against international humanitarian law's most fundamental obligation, which is the constant care obligation. When they know their operations will put civilians in jeopardy, even civilians who might hate them or might actually support the cause of their enemy, civilians, meaning not members of the enemy armed group, they must take constant care to do all that is operationally feasible to mitigate the risk to the civilian population. That means that before they launch an attack, whether it's a drone attack or dropping a bomb or a tank commander firing a tank round in the streets of Gaza, we need those combat leaders to constantly be asking, what can I do that will achieve my military objective, but will also mitigate civilian risk as much as feasible? Now, they're not required under the law to implement measures that compromise their military advantage. Although, to be candid, the IDF does this routinely. They assume greater risk. For example, We know now that Hamas has military assets under the Al-Shifa hospital. Israel decided to conduct a ground raid into the hospital. If you've been in the military, you know that a ground raid against an embedded enemy is one of the most dangerous missions you can conduct. I think legally, had I been the legal advisor, I probably would have advised the commander, you're not legally obligated to do that to reduce risk to the hospital. You could use standoff capability to try and attack that target. But obviously there was a decision that even though we might not have to use that tactic, we are going to use that tactic because we're trying our level best to mitigate the risk to the civilian population, the hospital, the patients. And we know now that right behind the raid came what? Medical supplies, Arabic speakers, medical personnel to try and, as best we can, reduce the risk to the civilian population. These are called precautionary measures. And there are, from a tactical standpoint, there are a lot of things a commander can do or consider to reduce risk. Timing of attack, weapons package, alternate tactics, warnings, evacuations. These are the standards by which we should judge the credibility of commitment to international humanitarian law and the conduct of hostilities. And the enemy bears an obligation as well. They bear a constant care obligation as well. And there are two fundamental things the enemy should be doing to mitigate civilian risk. Number one, wear some type of uniform so that your opponent can distinguish, as Arthur said, between who can be the lawful object of attack and who should not be. Because if you don't wear a uniform, you are going to exponentially increase the risk of mistake. And those mistakes will be reasonable, but they'll be tragic. And number two, avoid putting your military assets in the midst of the civilian population. And we know that on this ledger, the IDF is trying its best to mitigate risk, and Hamas is trying its best to exacerbate risk. And for me, that is the ultimate touchstone of respect for the law during the conduct of hostilities and responsible battle command. And on that ledger, there's no moral equivalency.
Arthur, may I ask you about proportionality? Proportionality is perhaps the most misrepresented concept. It is, of course, not a comparison of the number of deaths on each side. All that analysis does is encourage Hamas's use of human shields. Could you take us through what proportionality requires from law-abiding armies, and perhaps also touch on the accusation of genocide against Israel, which we have heard increasingly repeated?
So I'm going to start with proportionality. And I think you've managed to work two of the most misunderstood terms in international law into the question now, but I'll try to deal with them quickly. So proportionality is about the relationship between the harm you do to an enemy military and the military advantage you receive as a result, and the collateral harm that's done to civilians. And if the collateral harm done to civilians in the course of firing at a legitimate target, a legitimate military target, is excessive in relation to the military advantage gained, then there's a proportionality issue. All of this is viewed, keeping in mind, I think we've now all said it, that this is intent or conduct-based, not an effects-based inquiry. All of this is judged based on the information that the commander had available at the time that they were making the decision and the reasonableness of the decision they took in light of that information. So essentially, the military advantage that you'd be likely to get from the attack, the civilian harm that you'd anticipate was likely to occur. This inquiry only happens if you're firing at a legitimate target. Otherwise, the problem that you have is distinction, not proportionality. And then on the second, I think what we're talking about, certainly when we talk about genocide, distinction is a less serious term than genocide, but certainly we're talking about problems of distinction, not of proportionality. We're talking about seeking to destroy a group in whole or substantial part we're not talking about a situation where enemy armed forces are targeted in a lawful manner and there is collateral damage, that there's an inquiry how it relates to the military advantage that may or may not be excessive.
In terms of the prevention of evacuation that we've been witnessing, reports of Hamas bombing civilian convoys moving from the north to the south of Gaza, following Israeli requests that civilians leave the areas of Hamas strongholds in the north. Also harrowing reports of Hamas gunning down fleeing civilians in the street. What are the international law implications of Hamas preventing the evacuation of civilians in that fashion?
And the place I'd start is that both parties have an obligation to try to mitigate the risks to civilians. So both of them should be trying to make it possible for civilians to use humanitarian corridors that escape from places where the fighting is likely to be fiercest. And I want to make a distinction here because this is something that's been the subject of a fair bit of discussion in the international law community. An attacking party may, often should, evacuate civilians who live in a village that it is attacking. It may not expel civilians who live in a village that it's attacking. And the distinction here, the question, what's the distinction between unlawful expulsion or forcible transfer in legal terms and humanitarian evacuation, comes down, in my view, to three primary things. First, the reason that civilians are being encouraged to depart the area during the conflict. A party would need either imperative military reasons or a basis in the security of the civilians themselves to justify an evacuation. Second, and relatedly, the temporary nature of the evacuation. International courts have multiple times looked to whether a party was intending to let the civilians that it was evacuating come back. And third, not unlawfully creating the risks to civilians. So what you'd imagine as a situation of the gravest type of civilian danger that can occur solely through lawful combat operations is a situation where military targets and civilians are intermingled, often in the same building, often in the most protected type of facility. And Hamas, of course, the defending party, is also obligated to help separate its forces from civilians, and in this case is violating, or at least reportedly violating, that obligation by seeking to prevent evacuation.
Geoff, in light of proportionality that Arthur has set out, may I ask you, you've started to touch on this, about buildings and how proportionality applies with respect specifically to civilian infrastructure that has or is being used for a military purpose. So, for example, Hamas placing snipers on the roofs of residential buildings, or launching rockets from schools, or placing command centers within hospitals. How do you see that as affecting the proportionality analysis?
Yeah, let me step back a minute. By the way, I'm sorry I didn't answer your question about siege versus ceasefire, but it fits nicely at the end of Arthur's point, because
I was gonna come back to that, but go ahead.
I'm sorry, of humanitarian pause versus ceasefire.
Yeah.
A humanitarian pause is an aspect of that constant care obligation where you're giving the civilians the opportunity to leave a certain area for humanitarian purposes. That's very different than a ceasefire. A ceasefire is a general cessation of hostilities for an indefinite period of time. And so while I think there is compelling justification to expect Israel, when it's operationally feasible, to pause operations, notify the civilian population and humanitarian actors to facilitate their evacuation, that's very different than demanding an immediate ceasefire, because a ceasefire is inconsistent with that operational mission that I mentioned earlier, which is to destroy the enemy. The ceasefire is just going to make that harder in the long run, because they're going to be able to use that space and time to reconstitute as they've done before. Okay, regarding buildings, this is where I think we have the most trouble with using observable effects of combat operations to extrapolate assumptions about illegality. So we see in news videos images of buildings being dropped. And it looks pretty stark. I mean, you see a high-rise concrete building collapsing as a result of an attack. It's very easy to figure out who caused that building to fall. That's the party that launched the projectile, dropped the bomb, fired the artillery, whatever the case may be. But what international law really requires is an assessment of responsibility for that consequence. And oftentimes direct cause and legal responsibility for the destruction of property or the death and injury of civilians are not the same thing. We have to be very careful about conflating these. When the enemy uses presumptive civilian objects like a building or a vehicle or a hospital for military purposes under international humanitarian law, they have transformed that object into what's called a military objective. That means it loses its protection from attack. Now, you could say, well, look at how bad the destruction is. That must have been wrong. But that's like saying 1 + I don't know equals war crime. Because if you're trying to decide whether or not an attack that results in destruction of civilian property was or was not consistent with the law, you cannot just look at the results of the attack. That is relevant information, but it's not dispositive. What you have to do is you have to say, what was the target? What was its value? What were the attack options? What level of destruction was necessary to achieve the military objective? What measures did you implement to mitigate civilian risk? You have to look at all of that together and then get to that last point that Arthur raised, which is proportionality, which is by its very definition an incredibly ambiguous term. And by the way, if I'm advising a commander and I say to a commander, you're not allowed to attack that target if you determine that the civilian risk is excessive in relation to your military advantage, what is my commander going to ask me then? He's going to say, well, what does excessive mean? And Arthur would agree with me that that's the $1 million question. I can't give you, there's no book I can open and say, this is how much this is worth. It's a moral judgment, and it's carried on the shoulders of battle commanders who have to make this terribly difficult decision. So that's why I say again that what we really ought to be focusing on is, number one, how confident are you that it was a military objective? What information did you have and what efforts did you make to confirm that information? And number two, what measures did you implement to mitigate the risk to that civilian property or civilians before you launched the attack? So just as an example, 2 examples. Let's take the rocket that hit near the hospital that the media immediately said was fired by the Israelis. That was a double violation. Palestinian Islamic Jihad launched that rocket to kill civilians. They just killed the wrong civilians. They didn't want to kill Palestinian civilians. They wanted to kill Israeli civilians. It doesn't matter. The intent to kill the civilians was the war crime. And so they intended to kill Israeli civilians. That's a war crime. They killed Palestinian civilians. That's a war crime. Or take the example of watching a building collapse and you say, well, why do you have to drop all these buildings? Where does the Hamas subway run? Where are all these tunnels? They built them under the most densely populated areas of Gaza City because they knew that in order to destroy the tunnel, the Israelis are going to have to use such high density explosives that they're inevitably going to be compelled to destroy the buildings above the tunnels. If you think of a subterranean tunnel and you collapse it, what happens to the structures on the surface? They're going to collapse. Having said that, if I were an Israeli commander, destroying these tunnels would be a very high priority because my alternative is what? Put soldiers in them? I was in some of those tunnels in 2015 that were discovered running into Israel, and I was stunned at how complex and sophisticated they were. This is not an incapable enemy. This is an adaptive enemy that has been preparing for 8 or 9 years for this eventuality. And so we have to look at the effects of these attacks and step back for a minute. And it's fine to say, I'm worried that might have been excessive force, or I'm worried that you shouldn't have used that much destructive power on this target. But being worried or concerned about it doesn't automatically make it illegal. Unless you know all those other factors, you're speculating on whether or not the attack judgment was legitimate, legal, and necessary under the circumstances.
And of course, it's worth stressing that with respect to previous operations in Gaza, through from 2008, 2012, 2014, 2021, the consistent reporting on the basis of that analysis being conducted after the event is that Israel has maintained the requirements of the laws of armed conflict, and in many respects, perhaps even exceeded them. Arthur, may I for a moment drill down into the issue of human shields and ask, what obligation does Israel have with respect to civilians that are being used by Hamas as human shields, and specifically if you can address the particular challenge that arises from not knowing if these are civilians that have remained involuntarily or remaining in the hope that their mere presence will prevent Israeli action and its legitimate targeting of Hamas infrastructure.
That distinction that you mentioned between voluntary and involuntary human shielding is really important for status and really important for applying distinction and proportionality. Before I get to it, I want to refer back to something that Geoff said and make sure we're clear that what we're talking about is Israel's obligation in its response to a war crime, that the use of human shields is a war crime. It's in the additional protocols, it's in the Rome Statute, it's in the ICRC customary law database. There's no question about that. And so using that as a basis for a discussion, I think, is important. That said, I think there's a couple of questions that come up in deciding what Israel's obligations and response would be. The first is, do the shields become lawful targets themselves directly? And this is where the answer, if people are being involuntarily used as human shields, is definitely no. Israel and most others take the position that they cannot be directly targeted. They maintain civilian protections. And one of the things that means is going back to our proportionality conversation, our next level conversation, after we evaluate the principle of distinction. If you imagine a group of human shields around or inside a military objective, then when you analyze the civilian harm versus the military advantage and decide whether it's excessive, they'll count on the civilian harm side of the ledger. They'll make it less likely that you're able to take an action against that particular military objective. There's some legal uncertainty and disagreement about the status of voluntary human shields, but both Israel and the United States take the position that at least voluntary human shields may be directly participating in hostilities in a way that makes them lawful targets. So it may change the outcome of a conversation about direct targeting. Israel, going to the uncertainty that you talk about, has traditionally applied a presumption that people are shielding involuntarily. That is, if they don't have information one way or the other, they assume the shielding is involuntary, and they assume the person is thus a civilian who cannot be directly targeted, who must be counted on the civilian harm side of the proportionality ledger. I think that about covers what I'd say in response to that question.
Geoff, could I ask you to follow up with this concept that you've already identified, essentially aggravated human shields? What are the implications of Hamas seeming to want to cause civilian casualties in the way that you've described?
Well, I mean, I think there's legal implications and there's policy implications. And we need to keep in mind that when legal advisors in combat tell commanders, you may do something, it doesn't mean the commander should do it. The may is the legal question. The should is the operational strategic policy question. So I think one consideration here is, if we know Hamas is preventing civilians from evacuating a certain area because they're hoping that they become civilian casualties, there may be good strategic reason to refrain from conducting an attack. Of course, that gives Hamas some advantage as well, but that's a tough operational decision for military leaders. What's more important? That I attack the target and give Hamas the advantage of the images of casualties, or that I refrain from attacking the target. They don't get that advantage, but then I don't get the target. I think the attack in the refugee center is an example of how difficult that decision-making process is. So obviously, when Israel chose to launch that attack, there must have been an assessment that the kind of informational blowback from civilian casualties would not be significant enough to offset the benefit of killing the target. Of course, Natasha, the real irony there is the immediate media reaction was Israel attacks refugee camp, when my immediate reaction was, why was there a senior Hamas commander in a refugee camp? And we know the answer to that is because either way they win. So the implication from a legal standpoint is much simpler, I think. First off, I've never been an advocate of this involuntary, voluntary human shield dichotomy, because if I'm looking down the barrel of my rifle, how do I know whether you're there because you want to be or you're compelled to be? You're just a civilian. So to me, you cannot directly target those human shields, but there's a much higher probability that they are going to become incidental victims of an attack on the target because the enemy put them there. Now, you still have to do your best to avoid that. And as Arthur says, they're still considered in the proportionality equation. But if they're being placed next to vital military objectives, the odds of the proportionality equation leading to a legal no-go on that target goes down significantly by virtue of the nature of the target itself. And this is why I think in many cases, what Hamas is doing is they're hoping that Israel attacks the target. They're not naive. If you put civilians, if you put your command and control center under a hospital and the Israelis find it, they're not going to leave it alone. Eventually, they're going to have to do something about it. And so from a legal standpoint, I think at some point, and Arthur would be better at this than I would hope at some point, some international tribunal would consider the possibility that somebody should be held accountable for the murder of civilians, not because they were killed at their hand, but because they set the conditions where the other side to the conflict had no other option but to attack a target.
We only have about 5 minutes left, and I know that there's a very important topic which has routinely come up, and that is the concept of siege. Geoff, can I ask you to explain as briefly as you might be able to the laws that relate to siege, both with respect to the Gaza Strip as a whole and perhaps specifically Gaza City and the north of Gaza?
So it is logical and legal for a military to try and starve its enemy forces of resources and assets in order to weaken them. Remember, the principle of military necessity authorizes all measures not otherwise prohibited by international law to bring about the prompt submission of your enemy in the most efficient manner. But of course, when you have enemy embedded with the civilian population, there's another consideration, which is the impact on civilians. It is clearly prohibited to cut off resources for the purpose of starving the civilian population. But it's not clearly prohibited to cut off resources for the purpose of starving the enemy when that has a collateral or incidental consequence on the civilians. At that point, two obligations kick in. The first is you are prohibited from arbitrarily interfering or blocking the provision of humanitarian assistance for the civilian population. But what does arbitrary mean? Number one, they don't have a right to access that area if it will interfere with your ongoing combat operations. So for example, if there's one road in and you're using that road to bring in equipment and supplies, you don't have to give that road to humanitarian actors. And number two, you have the right to ensure or implement measures to ensure that the resources will not be diverted to the enemy. This is siege. Now, the other issue that comes in at this point, again, is this constant care obligation and candidly, a non-attack application of the proportionality principle. Because you do have to consider whether the value you're going to get from the deprivation is sufficient enough to offset the harm to the civilian population. And I think that the initial decision to cut off water and electricity is a good illustration of this. In a blog post I wrote, I raised a question on cutting off water. Does that really pay its way? Hamas gets Gaza gets 8% of its water from Israel. We know Hamas is going to have access to whatever water is there. So what is the real military advantage you're going to get from turning off that tap? And I took some flack on that, Natasha. Interesting, Arthur, from my brother who you work with, who says you don't have an obligation to supply resources to enemy territory. I agree with that. But on the other hand, I think that everything should be decided through the lens of military necessity, prima facie. Electricity for me was much easier because most people don't die without electricity. I understand that electricity is needed for hospitals, but there's a way to mitigate that impact. You can get generators or fuel through the Red Cross or Doctors Without Borders to go just to the hospitals. But when you're fighting a subterranean enemy, cutting off electricity and access to power is a highly important military objective. So I don't like this notion we talk about siege. I think the better question is, what type of siege tactics are legitimate in certain circumstances? And if we think about it that way, it's a much more precise assessment. And it also undermines this kind of what I think is relatively invalid accusation of collective punishment. Because what that accusation is doing is it's conflating collective consequence with collective punishment. And as Arthur knows, collective punishment isn't even a war crime in the International Criminal Court. Starvation is. But collective suffering is a consequence of war. That is not collective punishment. As long as you're using these measures to bring your enemy into submission, which is what I think Israel was doing.
And when we consider the concept or the notion of collective punishment in light of what you and Arthur have described, of Israel's intent and its conduct and its application of the rules of armed conflict in that context, it really loses all credibility. It certainly strikes me that it's based less on any application of the facts or the law and more on an attribution of evil intent to Israel, which I think both of you have indicated is fundamentally misplaced under any proper analysis.
Well, I would say improper intent. The notion of evil is a different level, but I think improper intent or invalid intent.
In the context of some of the reporting that we've seen and the misreporting, I'm bound to say, especially in light of the clarity that you and Arthur have brought to this assessment, it may go even further than that, Geoff, but I certainly take the point. Arthur, is there anything finally that you wish to say before we wrap up on that point?
I'd agree with all of that. I think my bottom line on sieges and tactics associated with it is that they will go back to distinction, precautions, and proportionality, and we'll analyze those measures in the same way. I think that's an accurate bottom line statement of the law as far as I'm aware of it.
I'm tremendously grateful to both of you and of course to Colin and everyone at who have put this webinar together and organized it. I hope there will be many more to come. Extremely grateful for your insights and your expertise and that it's enabled us to cover both the practical side of the law of armed conflict on the ground, but of course also how it is likely to be applied later in the context of international tribunals. I know our audience is primarily lawyers, so I'm sure all of us will be watching this space. It's very good to have seen both of you in this context. Thank you for your time and your insights.
Thank you, Natasha.
Thank you, Natasha.
Bye-bye.